Hi, everybody. Tim Andersen here. Thank you for joining us today. We appreciate it. This is another edition of Movers and Shakers, and we've got one. We've got our attorney from Kolby Reddish from Boise, Idaho. Now, Colby's been with us before. He's experienced in all facets of law. He has worked with real estate appraisers. And given the fact that he is an attorney, he is familiar with real estate appraisers. We've asked Colby to talk to us today about what is going on with the Sitzer-Burnett decision relative to the National Association of Realtors. Now, this is obviously not something that is keeping the majority of the population awake at night with worry. But for those of us in real estate, we need to be aware NAR was the defendant in a class action suit in Missouri. Sitzer-Burnett were the primary defendants. There were others. NAR was were the primary plaintiffs. NAR was the primary defendant, but there were others, and some of those other defendants have settled out. But anyway, the court basically said, realtors, you're guilty of all sorts of ickiness, and we're going to hit you with a $418 million fine and or excuse me, a $1.5 billion fine. And the National Association of Realtors said, why don't we settle for 418 million? So the plaintiffs, the remaining plaintiffs, have agreed to that. The court hasn't. That's pending, but it looks like it's going to go through. And of course, we've asked Colby here today to explain to us what's going on. So with that overly windy and lengthy introduction, Colby, thank you for being here. Welcome, my best to your family, and we'll mention your new puppy. And tell us what's going on with the good folks in Chicago and NAR.
Well, yeah. So let me break that down a little bit. So the National Association of Realtors, like you said, they have been litigating multiple different lawsuits in multiple different states. I think some in state court, some in federal court, that have been brought by both groups of home sellers and several of the major brokerages. And the arguments in these cases have really turned on whether several rules of the National Association of Realtors have unfairly engaged in price inflation specifically by propping up agent commissions, by overinflating the value of homes to increase agents' commissions. Now, the National Association of Realtors, is the largest national trade organization of real estate brokers and agents. It's based in Chicago, like you said, Tim, and it boasts nearly 1.5 million members across America. Now, the argument in these various lawsuits was that there are several association policies that violate federal antitrust legislation. I'm going to touch on 4 of those rules right now. So the first was what is known as concealment rules. What those rules that were adopted by the association do is they prohibit multiple listing services from disclosing to prospective buyers the amount of a commission that a buyer's broker will earn from the home purchased on that MLS. The second policy that was challenged is a policy that allowed buyer brokers to mislead buyers into thinking that buyer broker services are free, basically by wrapping them in a way that they were kind of obfuscated and not directly apparent to the buyers. The third policy that was challenged enables buyer broker agents to filter MLS listing based on the level of buyer broker commissions. So it actually, when a buyer broker was using the MLS service, they could filter based on the highest commission for that buyer broker, and they could even exclude homes with lower commissions from consideration. And so that would basically steer home buyers into those higher commissions. Basically, the argument is that that was basically violating duties that they owed to their clients. And then the last was a policy that limited access to lock boxes only for licensed brokers to have physical access to a home that is for sale, to those that are affiliated with an NAR affiliated MLS. And so those really are the 4 policies that were being challenged. The argument was that these policies collectively unfairly lessened competition amongst brokers to the detriment of home buyers. So, as I said, legally, the argument was that this infringed on federal antitrust law. So, for those who are unfamiliar, antitrust is the same type of legislation that is used to strike back against monopolies. And so that allowed the federal government's Department of Justice actually to take action aside from the plaintiffs that you mentioned in that lawsuit, Tim, and aside from, collective home buyers organizations or from brokerages. The Department of Justice's position was that the association's adoption and enforcement of the rules that we just discussed presented a concerted action between horizontal competitors to raise prices and lower the quality of their services to their clients. So when we're looking at antitrust issues or we're looking at monopoly issues, what a horizontal monopoly or what horizontal price fixing amounts to is amongst competitors, right? Amongst horizontal competitors. Now, there are also vertical monopolies that sometimes the government takes action against. That's more akin to like the Microsoft litigation that took place in the early 2000s, basically that one company controls too much of one industry. So looking at the settlement that the DOJ has reached with the NAR, the DOJ's position was that each of these policies violated the Sherman Antitrust Act of 1890 by unreasonably restraining trade. And I think that's just an interesting thing, is that our most salient, our most powerful antitrust legislation actually dates back to 1890. I think it really just highlights like the proud history of antitrust actions. We know that Teddy Roosevelt, my personal favorite president that we've had here in America, he was a big antitrust proponent. Anyways, aside from the legal basis, if we go back to really what's at issue, the Department of Justice and the association, they reached a settlement whereby the association will no longer be able to adopt or enforce any rule or practice that directly or indirectly causes these same effects. So they've reached basically what's a stipulated settlement. The NAR is not going to move forward with these rules or enforce these rules any longer and is going to pay a certain amount. As you said, they basically have offered to reach this collective agreement to pay over $418 million over the next 4 years to settle all the continuing ongoing litigation. It's important, I think, to remember that the DOJ's role in this, the federal government's interest, is to protect the public from unfair competition. So that's where their focus is, and the settlement with DOJ does not explicitly affect the other ongoing litigation that involves the association. Like you said, this settlement is being reached after a federal jury ordered the association after trial to pay almost $1.8 billion $1.8 billion in damages based on this artificially inflating real estate prices based on the commissions. The idea was that this was accomplished by adding buyer's agent commissions by standard practice to the sale price of the house. So one thing that's worth noting about that litigation, if it continues, if it doesn't settle out, is that treble damages are at issue in one of these continuing lawsuits. And so that $1.8 billion, at least in theory, could be treble damages, just means tripled. And so it could be tripled by the court if it decides that these practices were so far over the line in violation of antitrust. So in coordination with the payments, and this is fairly standard, it's important, I think, to note that the association maintains that it did nothing wrong, but it's making these changes, that have been suggested by DOJ, suggested by the plaintiffs, and these changes will be made to the MLS rules that the association has starting in mid-July 2024. So we're just a few months out from that. What this will mean is that buyers' broker fees will need to be negotiated more openly outside of the MLS platforms. What we'll see is that a lot of these things that previously were automatic or standard, they're going to be increasingly a point of negotiation. One of the things that has been discussed is a new rule requiring buyers' agents to enter into written agreements laying out the true cost of their services. That was already an existing rule, but the idea is that they want to expand the disclosure to get into home buyers, more upfront communication about what they're actually agreeing to and how their buyer's agent is benefiting from that arrangement. So I think the application of these settlements, aside from the fact that they're very interesting to anyone who has or will buy a home or, has interest to a large segment of the population, I think as far as appraisal goes, one of the things that's interesting to me that we'll just have to track and see if this bears out is that, the standard practices that at least has been argued have overly inflated home prices. That's obviously, if we see corresponding decreases now that those rules have basically been given up by the association due to this litigation, it'll be interesting to see how that affects home prices. And obviously, if it affects home prices, then it's going to affect, the sales prices, and it'll affect the way that appraisers work on their sales comparison approaches. Now, I guess one thing I just note, kind of in closing on this issue, the entire purpose of federal antitrust legislation in the first place is to ensure that we have fair competition in the marketplace, that consumers aren't being unfairly taken advantage of. And so I think it's an interesting win as someone who's a big proponent of consumer protection laws in the first place. I think it's a big win for the American people to have this increased competition.
Kolby, from a standpoint of the consumer, which you just mentioned, all right, in the past, somebody buys a house for $500,000 and 6% commission, and 3% goes to the selling broker, and 3% goes to the broker who bought the buyer in. Now, okay, many, many years ago, I was a broker, but I gave that license up a long time ago. Even though the buyer might have come to me and said, help me purchase something, help me purchase some real estate, house, condo, whatever. And therefore, the implication was that I was working on behalf of the buyer, but yet I was looking to the seller for the commission. Therefore, I was working for the seller. But yet, wasn't what NAR said, hey, this is cast in granite. This is never going to change. Wasn't what NAR was doing basically making the seller pay for somebody who was negotiating against them?
Yeah, I can absolutely see that argument. And I think that's one of the things that we'll see come out of this is these things that were standard for a very, very long time. It was almost as if no one had thought about its implication as applied to antitrust. And as far as why now, I guess would be the question, right? The kind of your question makes me go to next. Think why now? I think a lot of it has to do with the increases we've seen, especially in commercial or in residential real estate, right? And so I think the argument that this, collectively these schemes all together, and when I say schemes, I don't mean anything nefarious. I just mean it was a cohesive program, right? They were having the effect of, because of that shifting that you're talking about, they were having the effect, at least arguably, of overinflating home prices based on agent commissions. And so I think that's where it will just be really interesting to track this and see how accurate, that those presumptions that we were bringing to the table in this litigation, how accurate they were. Because what we should see, if the arguments are true and if the settlement is going to really affect meaningful change, we should see corresponding drops in home prices. We should see a lot of these things that previously were just thought of as standard as being more up for negotiation. And I think, the part that you're asking about as far as who's compensating who for what, I think that's the other interesting thing is that I think in theory, we'll have to see how this shakes out, but it will allow for buyer's agents or it should require buyer's agents, I should say, to be more open about how their compensation works, because I think a lot of people just really didn't understand exactly where the buyer's agent was making money.
Okay, let's continue on with this issue of commissions. All right. Now, ever since I got involved in real estate appraisal, the standard thinking was, hey, a house is worth whatever it's worth. That's its market value. We don't care what the commission is. There might not be a commission. There might be a 3% commission. There might be a 10% commission. 10% commission. We don't care. The house is worth, $300,000. But now, given the implications of this decision, given the implications that sellers were not really willing to come off their prices too far, because instead of giving 2 or 3 or 4% to their broker, they were giving 5 or 6 or 7% so that it could be split between two brokers, one of whom may have been working against the seller. So have we as appraisers been overlooking the elephant in the room, that the commission, because of the way NAR structured its commission schedule, that people were overpaying for real estate, thus unnecessarily inflating its price?
Yeah, I think that is absolutely accurate, Tim. And I think that will be the real interesting thing to see is how this will affect home prices going forward. Because really what, the high level view I take of this is that the way that this was all structured was essentially wrapping the commissions. I mean, that was the practice, right? It was wrapping the commissions into the sales price of the home, when really that 6% or whatever the percentage was, it had nothing to do with the value of the home, right? It was really for an entirely different service. It was just being wrapped up into the same transaction based on these rules. And so that will be the real interesting thing to me, is if we see corresponding drops in prices, or even more creatively negotiated structures for how that compensation will work in the future. I think that's really what the association is looking to now.
Okay. In light of more negotiated commissions, more negotiable commissions, and now that the buyer's broker will not be able to depend on a two, well, really anywhere from 2% to 3%. Do you see this as decreasing the number of brokers out there? And then, as a follow-up question to that, do you see this as decreasing the number of members NAR is going to have?
Well, I had trouble hearing your first question because I think I had a little bit of disruption in our connection. I'll answer your second question and then I'll ask you to restate the first one. It will be interesting to me to see, because one of the rules that was that had to be lifted from NAR had to do with physical access to the properties and basically what was known as the lockbox policy. And so because of that, it will be interesting to me to see if it decreases basically the power that the association has over these smaller brokerages. I think it's important to remember that there were a number of brokerages that participated in these lawsuits against NAR as plaintiffs. And so it will be interesting to see. I can't predict the future, obviously, but it does seem like, because one of the rules was aimed at decreasing NAR's power over brokerages, that now that that rule is not in place, there's not as much leverage. And so it may be interesting to see how their membership adjusts accordingly.
And that was basically my question. Are we going to see a decrease in the number of agents? Now, let's roll this over a little bit into appraisal world. Maybe there are fewer agents out there,
Mhm.
and maybe the very basis of real estate appraisal, which is the MLS, gets attacked. For example, one of the original defendants, but who settled out before NAR settled, was Keller
Mhm.
Williams. And this is not to denigrate Keller Williams. That's not the point. But Keller Williams is huge, and it's got literally dozens of thousands of agents across the country. Now, given that, isn't it possible that Keller Williams could say, "We don't need an MLS. We got, we're the dominant force in just about every market in the United States. We got our own MLS. Why in the world should we buy into a system in which we're putting three-quarters of the data anyway?" So, and then Keller Williams says, "Hey, well, this is, our brokers who give up, either pay us outright every month or give up, anywhere from 30 to 50% of their commission to be part of Keller Williams. They get access to our in-house MLS for free. But appraisers, if you want it, sure, it's going to cost you X per month. And is that going to be $20, 200, 2,000? Nobody knows. So my question is basically, given this decision, and given the fact that there are now fewer brokerages than there were before, and those fewer tend to be bigger, which had nothing to do with the NAR decision. But do you see the MLS as we have it now, as we use it now, going south in one way or another, or is it going to continue on, maybe limp along? But other than the fact it won't list the buyer's broker's commission, it won't change at all. What are your thoughts on that?
It's an interesting question. And I think a lot of them are unsettled. So it's kind of fun to think about these aspects. And again, I just say, we're kind of spitballing here. I can't predict the future, but one of the things that is interesting is that aside from the listing that you mentioned on MLS, involving buyers brokers, one of the other changes, one of the policies that we talked about is that the MLS will no longer be able to. There was a rule that allowed for buyers brokers to sort MLS listings by basically by the commission that they were going to make, right? And so they could even completely not look when they're working on behalf of a buyer at those properties that they felt like weren't going to offer them sufficient commission, which in my mind, that was a very problematic system. I think we can all see why that was a very problematic system. If you're working in some type of fiduciary or professional capacity for someone, but you have this conflict of interest where you're incentivized by that, by the way that MLS service allowed for sorting, you're basically incentivized to only look at the properties that are going to pay you the most, not necessarily what's best for the buyer. I think that's one of the reasons that rule had to go, along with just the effect it had on competition itself. So your question about, these larger brokerages is really an interesting one. I think anytime we see a big sea change like this in an industry, it's really hard to predict all the follow-on effects. One of the things that will be interesting is as if certain brokerages move in that direction that you asked about, like separating from a third-party MLS to just using like an in-house system almost exclusively. I think one of the things that will be interesting, since we're on the topic of like antitrust and monopoly litigation, is whether that in itself will get too close to vertical monopoly. The idea that one company basically controls too much of the industry from top to bottom. Again, there was litigation with Microsoft and the DOJ over this in the early 2000s that helps navigate, when an impermissible vertical monopoly exists to unfairly restrict competition in the marketplace. And that's just where my mind goes, is that as we see these changes, it will be interesting to see, how they work. I think one of the things that's very interesting, just because of the way that our legal structure works and the way that our economic system works, is that you do tend to see exactly like you said, and it isn't unique to real estate appraisal, right? It happens in every industry. You get smaller businesses that grow into larger businesses, and then when you have some type of seed change due to litigation like this, it's difficult to tell. In some ways, people look at it like, let me wave my light back on here. There we go. In some ways, people can look at it like, fish in a pond. Like you have a smaller company that might eat an even smaller, or you might have a small company that eats an even smaller company that is then eaten by a bigger company. And so that's, I guess, one of the things that I can see coming out of this is the way our economic and legal incentives work. We do have, like you said, a smaller collection of larger brokerages. And so it'll be interesting to see the solutions that they look to, specifically with regard to MLS. It's difficult for me to predict, but that will be the thing to watch, I guess, is the moves that they make, whether they get too close to, at least in theory, like a vertical monopoly, right? Cutting too many people out, putting too much power into basically one company from top to bottom in an industry.
Okay, vertical monopolies. All right, let's talk about that for just a second. Now, okay, so you've got brokerage X that has half to 50% of the market in, Denver. Okay, so again, I'm not asking you to speculate because there's nothing for me to speculate on. But the issue is the fallout from this NAR decision is anyway. There apparently are going to be there's going to be more than just real estate fallout. There's going to be potentially legal fallout as well. So literally, the ramifications of Sitzer-Burnett could go on for a decade.
Oh, absolutely. I mean, this type of class action litigation, because many of the pieces of litigation were class action, and I've never done class action work yet. I just have observed it. And one of the things that's interesting is it is that way. I mean, realistically, they can take decades to resolve the complete follow-on effects of all of the different parts of this. And so while it's interesting, the settlement that's been agreed to and that in theory is moving forward, there will be a lot of continuing discussions on that. You're absolutely right about that, Tim.
All right. One last question. Okay, Fannie Mae and Freddie Mac hold, I don't know, 85% of the mortgages in the United States.
Mhm.
And there are those who think Fannie and Freddie are wonderful, and there are those who don't. Now, let's look at this from a standpoint of what they're doing. Obviously, they loan money to help people buy houses.
Mhm.
Well, let's suppose prices drop because of what we've been talking here. And Fannie and Freddie are not lending as much money because prices are lower. All right. Now, given that prices are lower, and basically I have two questions. Do you think Fannie is going to look at that and from a standpoint, or as it looks at it from a standpoint of risk, that Fannie is going to say, that, lower price is not nearly so risky as a higher price, so we'll make the loan. And therefore, because of this lack of risk, or what they may perceive as a lack of risk, they're going to get fewer appraisals. And therefore, there is a need for fewer appraisers in the GSE uh, continuum of mortgage lending. Do you see that as a possibility?
Yeah, it's certainly a possibility. I'm not sure if if the price drops that we think will happen from this settlement and from these rule changes with the association, if they will be so appreciable that we'll see an industry-wide change like that. It's certainly possible. I don't know how likely I would see it being. I think that we'll probably see that kind of standard in the industry probably continue about the rate that it is now. But your guess on that is as good as mine. It's certainly possible that they'll look at the corresponding drops in prices that way. But I think where their interest is in really protecting, making sure that there's enough value there to make these loans in the first place, right? And so I think an appraisal is probably going to continue to be a fairly important part of that, even with small drops in prices.
Okay, so what you're saying basically is that obviously there's going to be the natural attrition of real estate appraisers. They retire or they die. They win the state lotto and move to Tahiti, whatever. But you're not seeing you're not seeing Sitzer-Burnett in and of itself as a catalyst that is going to decrease the need for appraisers. Is that correct?
Yeah, I don't see it appreciably changing that, because I think at best, the price drops that we'll see. Well, it'll be interesting to see. I could be completely wrong, and we could see much more significant price drops than we're thinking we'll see from this. And that's where this type of stuff is very exciting to me, because anytime, it's a little bit like throwing a rock into a pond, right? Like this pond, of the way this industry has worked, some of these standards have been settled for a long time. And now a lot of those standards that have been settled for a long time no longer can be the way that they were. And so in that sense, it's a little bit like throwing a pond into still water, and we get to see all the ripple effects. And it'll be difficult to predict all of them. And we may see some of the changes that you're asking about, but I think, since lenders are always going to be primarily concerned with making sure there's enough value in the property to support that loan, just in case there's a default, right? That's where I think appraisers are going to remain critical in helping the banks ensure that they're sufficiently protecting their own interest in these loans.
Okay, excellent. Thank you. Kolby, I appreciate it. This has been most eye-opening. I appreciate you keeping up with what's happening with NAR. I appreciate your explanation. I appreciate the fact that you were able to sort of peer into the future on some of this, because again, there are a lot of appraisers out there who know what happened, but don't know what's going to happen. Um, and which is one of the reasons I wanted to have this opportunity to speak with you today, for which I'm very grateful. Thank you.
Well, thanks,
Now,
Tim.
we're sure we're pretty much out of time, but you and I are going to do another one of these, and we're going to talk about persuasive techniques and how that's going to help appraisers become better writers. So everybody, we'll be back with Kolby, and we'll we're going to be talking about some boots on the ground appraiser stuff, so how to write more persuasive reports. So until that time, hit those like and subscribe buttons. Kolby, if someone needed to get in touch with you to ask questions or perhaps even retain your legal services, how would they do that?
Yeah, so my name's Kolby Reddish, and it's Kolby with a K, which is always I've had my name misspelled my entire life. So if you want to try and locate me, it's Kolby Reddish. I work for I work for a law firm in Boise called Smith Malik. So people can locate me on the Smith Malik website. They can find me on LinkedIn. They can feel free to email me. It's kolby.reddish, reddish, at gmail.com is my personal email. And yeah, I'm more than happy to answer any questions. As always, if I've slightly misstated anything, I always welcome correction as well, or other people's input or viewpoints. One of my favorite things about doing these types of, whether it's podcasts or just having discussions with people like you that have, they have expertise in their field, and then our fields kind of overlap in some way, right? I love this cross-disciplinary aspect of these types of conversations. Is that's one of the reasons I've loved working with appraisers in the first place. Is I think their world is so interesting, and I definitely don't understand it as well as I should, but I understand my part of it, and I understand the legal aspect of it and how their world relates to the law. And that's one of the things that I like so much about these conversations. And I thank you for having me on again.
Oh, it's my pleasure. Thank you. It's great to be with you. All right. Thanks, everybody. Again, hit those like and subscribe buttons. And we'll be back in the not too distant future. And we're going to talk about how to write better appraisal reports. Thanks, everybody. Bye bye.